Port Seal and the state authority announced that Don started I all certain guys will report it all here and give attention will be heard. The God save the United States of America, state of Florida, and then Honorable Court. Please join in the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Since today's September 11th, I'll put it together in just a moment. You may begin. Good morning. I am Judge John Stark presiding today. To my right, I have Judge Nardella. And Judge Smith is to my left. We have 3 cases. 2 of them are scheduled for 11 a.m. We'll take a brief recess in between those cases and the one that's scheduled for 11. We'll ask everybody who's here in the courtroom, please put your phones on silent or stun so that it's not disturbing anyone. And please have proper courtroom decorum at all times. Going to get started this morning with case 24-0108. And it's, I want to make sure I'm saying this right. Is it Labadie?
Yes, Carol.
Okay. The Labadie versus Orlando Health et al. And Miss Carol.
Yeah.
And then the council table we have. Well, okay, Mr. DeLuca. Okay. With that, Ms. Carol, you're recognized on behalf of the lab.
All right, thank you, Your Honor. Good morning. I'm Jennifer Carroll here on behalf of the plaintiffs in this case, Norma and Jude Labadie. I would like to reserve at least 7 minutes for rebuttal. If I can.
7 minutes?
Yeah.
Okay.
Thank you.
And we've got to change this real quick.
Okay.
Okay.
All right. Thank you, Your Honor. As we all know, every medical malpractice, medical negligence case is a battle of the expert. In this case, the plaintiffs, Norma Labadie and her husband, lost this battle well before the case even went to the jury. The jury had expert testimony connecting the dots, deviation of nursing standard of care, or the lack of it from the defense side. They didn't have that connection from the plaintiff's side. Plaintiffs were denied their right to present their theory of the case to the jury as a result of the exclusion of Nurse Attard's critical testimony regarding the defendant's deviation from the applicable standard of care. What's, I think, critical in this case, and that's why I want to lead with this, is the defense had their expert, their nursing expert, Tracy Key, give all sorts of testimony. She said she reviewed all the depots, all the records, and she was allowed to give testimony to the jury that nurses, hospital, never negligent. And nurse and Vasquez met all the requirements of pre-admission testing. And she specifically told the jury that all the symptoms that Mrs. Labadie presented when she went in on that day, August 9th, and other days, she had no obligation, Nurse Vasquez had no obligation to call Dr. Phil.
Counsel, did you, or at least it was trial counsel, did they raise a timely objection to that testimony?
Oh, as far as Nurse Keith's testimony, no, I'm not aware of that, Your Honor. I would have to, I guess, check the record again, but they were in a position where their expert testimony, their nurse expert testimony was going to be excluded on these specific issues. And that's what's critical here, is that the defense was allowed to go forward and give all this testimony by their expert, their nursing expert.
But counsel, wouldn't they say that testimony was properly disclosed and your testimony was not properly disclosed?
It was properly disclosed. The framework in this case, and let me just, put it in context here. First of all, you have, was Binger even applicable here? Because was there a deviation from the Discovery Depot, et cetera? And then, and of course, our position is really that it was not, okay? And if you say it is a new opinion, you still have to follow Binger in the analysis, and that was not done. And if we're talking about Binger, you can still have, even if it's a new opinion or a variation, the trial judge was required to analyze, was the prejudice to the opposite side, and this trial judge did not do that here.
Well, counsel, can we talk about that? I want to skip over your first issue, which I think is deserving of treatment, and this is if it's actually undisclosed. But
Right.
if we get to the Binger analysis, we're
Yeah.
sitting with the trial judge who's reviewing a deposition that was taken before, taking Binger objection after Binger objection after Binger objection. The one that we come to here on Nurse Attard's opinion, she did not go, you are right, through all steps of her analysis, but where in Binger does it say she has to make findings on the record each time she makes a Binger ruling? It just tells her what analysis she needs to follow. Am I incorrect in that?
Well,
Does she need to state on the record how she goes as to each of the factors in Binger?
she has to analyze it, and it's either going to be on the record, or that's how you're going to tell. It's either on the record or in writing.
Well, let's
But
go back to the record, right?
yes,
She took a Binger objection as to chest pain immediately before she took this Binger objection, correct?
yes,
On the chest pain analysis, she does go factor by factor in the Binger analysis, correct?
that's right.
Which tells me she knows it,
Right.
okay? So what's the evidence that she didn't apply it when she came to your,
Well, there was another discussion, of course, with regarding, it was separately done, right, as to each excerpt of opinion testimony, right? And she did it on the chest pain, that's right. But on the others, on the specific testimony that we laid out in the brief, and I can quote it again, but
Yeah.
specifically, yeah, the presence of pain would cause any nurse in a pre-admission testing to do some fetal monitoring, to call Dr. Feld to see if he's willing to perform an NST, what's an NST. And then continues, after Nurse Vasquez performed the respiratory therapy, did Nurse Vasquez report this at the chain of command? No. Does the applicable standard of care require Nurse Vasquez to report the respiratory therapy up the chain of command? Yes, all that was excluded. And then with the diagnosis of preeclampsia also, which that was included, Nurse Keith was allowed to go into that issue as well. So the judge did not address the issue of prejudice to
On
the other
the-
side with respect to this particular excluded testimony.
she didn't do it on the record.
Right.
We don't know if she did it in her head.
Well, I think that's all we can really go by is what, I
Well,
don't think we can speculate what she
well,
was saying in her head.
The question that was asked, I'd like to answer it. Do you believe that it has to be verbally stated on the record each and every time? If there's 13 different objections, they have to go through that out loud verbally every time, or we must overturn this case?
I think they do have to go through it on each time because each excerpt is a different issue.
Okay, so let's say they have to go through it every time. What
Okay.
obligation does trial counsel, when they don't go through it, have to bring that to the trial court's attention so they can correct that error in the moment instead of put it in their back pocket, wait for an appeal and say they didn't on the record state their findings as to each factor?
Well, I'm not sure, would they really be required to bring, I don't know.
Well,
of anything
right
that
now
says
you're
they're required to
complaining
Bring that to.
That the trial judge did not make findings on the record, correct? As to a Binger objection, and she had made those findings as to previous Binger objections on the record. So you have this moment and this exchange, right, with the trial judge right there. You can look at the trial judge and say, Your Honor, with all due respect, you have to make findings on the record as to the factors in Binger if you're going to overrule our objection. Or, I'm sorry, sustain their objection. That did not happen in this case, correct?
Yeah, I'm not aware of that, but I'm not aware of any case that says that you're required to. There's case law after Binger, and I think I cited in the brief too, that the judge does have to, I want to state this right, but the judge has to make, let's see, have held, and this is the Calera case, that's a 2021 third DCA. The Florida trial courts must evaluate the Binger factors and assess the prejudicial effect of excluding so-called late disclosed evidence before excluding testimony, and failure to do so is reversible error. So I don't see that logic, that really would work here. If you're gonna say, well, you can do it one time, and we're gonna assume, trial judge, that on these other opinions that came out, right, that you're excluding, you don't have to make the findings on
But
that.
why would
I
I-
think you would. I think it too.
Why would I assume the opposite, though? That my capable trial judge doesn't understand the Binger analysis when she just did it? She just did it 5 minutes earlier.
Then she knows it, yes. So if she feels a need to do it for this one piece of evidence, one piece of excluded testimony, why wouldn't she be required to do it for other pieces of excluded testimony? Because they're all different. What if you have, you try to analyze the issue of prejudice, let's say, okay? You can have, maybe there's no prejudice with respect to this one written testimony. But there could easily be prejudice with respect to this other piece of testimony. And in here, it's very significant because Nurse Key was able to testify. So the defense was able to prepare for all these issues, but especially the excluded testimony that we're talking about. Particular deviations from the standard nursing care in this case. And that Nurse Keith was able to specifically do that. That satisfies the criteria in the case law that, okay, the defense was able to prepare on this issue. They had their experts testify on these issues. So you can say, there's no prejudice here. There's no prejudice. Now, maybe on another piece of testimony, another excerpt, there may not be prejudice, right? Because maybe, you don't have that same situation. So I think every excerpt, right, is going to be a separate analysis. And I think the trial judge has to engage in that analysis with respect to each opinion that's being extended. And that I think is significant. I think it's tough when you go along that line to start speculating. What
No, I
the judge
appreciate
is
it, counsel.
thinking.
And I interrupted you. You started
Oh,
with your first
okay,
point,
okay.
which is
Well,
that they,
Anyway, yeah, so I just think that's really critical because as you know, in the cases I cited, which by the way, Appley did not even respond to in their brief, and very significant cases, where the law is clear that you don't even have to, I'm trying to think on the reports and going to that issue of, do we even have a Binger analysis here? You're not going to hold the experts verbatim to their reports. That would be absurd, I think is what the case law said that I cited in the brief. And on that first issue, I don't even think the Binger analysis applies here because there's no new opinion here, all right? The discovery depot was taken. Nurse Attard's report was attached to that depot. And if you read that depot, the only questions that defense trial counsel asked was in the beginning with respect to what documents did you review? Oh, that's a page such and such of your report. But they never got into the concerns, the numerous concerns that she expressed in that report. And if you read that depot, there's a lot of leading, a lot of arguing with the witness and a lot of cutting off the witness, okay? And that was well in excess of a year, right, before the trial depot, way before the trial. They had ample opportunity, if they had any concerns, if they needed to read the report, whatever, to investigate this. And also, even the trial was several days. So they had a chance to, if they needed to elaborate, further, to investigate it further, they could have, but they really didn't need to because they had all this information. They had all the medical.
So counsel, if I'm understanding your position right, you're saying that if a trial court order says that you have to disclose your expert witness opinions, that it's sufficient disclosure if your expert knows it and has the opinion and somebody didn't ask them the opinion. That's disclosure?
Yeah,
And what case do you base that on, counsel?
Tell you what disclosure is, especially. in the
Counsel, but what
report.
case do you base that on? I'm not familiar with any. I think I understand Binger, maybe at least average. I've never heard anybody argue that position, but I'm curious if you've got any case law to support that position.
I do, and it's in the brief because I'm trying to think of the name of it. I'm going to have to, if I can bring it back on rebuttal, because I have time to look at it. But I know I've seen the case on that. Because it says either in the discovery deposition or in the report. And that's why I think the report is very important.
I mean, I don't think the report expressly has this opinion. I mean, if it did, I think you would have put it in your initial brief.
Well,
but,
actually, I think I did put it in my brief. And if you read, and I'm just going to refer you to pages because I want to reserve rebuttal time. But I would refer the court to pages 16, 17, 18, 19, and 21. Actually, and that continues on 22, where what the nurse at Tard is talking about a lot of things, and I know that the opposing counsel wants to say, oh, it's just about lab tests, and that's all she was saying. But no, if you look at the report, she goes extensively into other matters, and she mentions pain, and she talks about, I want to get the exact quote, but taking everything into account. She spoke in those broad
Randy, you're about to
terms.
sign this, so you'll.
Oh, okay.
you can do this As you would like.
Okay, I just wanted to finish, but she spoke in extensive terms on taking into account everything. And I think what the defense wants to do is limit it and say, no, she's just talking about this. But, and that's what they were trying to do in the discovery depot and kept cutting her off. And I did not cite you the pages of that. But no, they needed to have been asking about the report and the opinions that she was stating in the report. And that's why I go to those cases, they're in my brief, and I'll pull those sites that say you cannot say, oh, if you did not mention every exact word, then in your report, then you can't testify to that. And the cases say, no, that's an absurd result. You can't require that. I just want to leave my remaining time for rebuttal. Thank you.
Counsel, you recognize.
May it please the court. Good morning. My name is Taylor McLeod and I'm with the law firm of Wicker Smith. My co-counsel, Michael DeLugo, is seated behind me and we represent Orlando Health. We are here on two issues. The first is whether the lower court committed error and abused its discretion in striking the very limited opinions of plaintiff's nursing expert Janet Tard. And the second is under de novo review, did the trial court violate the plaintiff's due process rights? Now, at the outset, I think it is critical to emphasize the fact that Nurse Tard was not stricken as an expert. Her trial testimony was merely limited to what was contained in both her discovery deposition and her written report. There are three limited areas that were stricken. Two were based upon the fact that they were not previously disclosed and therefore were Binger issues. And then the other one was stricken because her testimony exceeded her scope as an expert. The question regarding expertise was regarding preeclampsia and whether she was qualified to opine as to what a doctor is supposed to do once a patient is diagnosed with preeclampsia. And then the other issue is with regards to abdominal pain and whether the presence of abdominal pain specifically would cause a nurse in pre-admission testing to call the physician.
Counsel, can you get into that? And maybe you're about to, but your opponent says that that was disclosed. And I think that's preliminary. Do we even get to Binger? Is it disclosed or undisclosed on abdominal pain?
It is undisclosed on abdominal pain. And as you can see, the trial court went through a very extensive analysis of abdominal pain. And in fact, the plaintiff's attorney in the hearing, in the argument specifically stated, no, abdominal pain is not in the report. And abdominal pain is also not in the deposition. So that is very clear. And like I said, I think on, let me pull up a specific citation for you. But the plaintiff's attorney on page 265 of the trial transcript specifically said, I concur with you, that is not in her report.
Right. So that's after the trial judge says, I looked for these specific words are not there. And there was a concession as to that. Could they make an argument generally that it was disclosed without using those specific words?
No, Your Honor. The discussion regarding pain was specific to chest pain. And that the trial court overruled our Binger objections that we were not on notice of a chest pain complaint. And so that I believe Your Honor pointed out at the start of the court's analysis, she went through a very extensive Binger discussion regarding chest pain. And she did say, okay, you could potentially see that there's some chest pain and you were on notice of that. That was not the case for abdominal pain.
Could they climb the ladder of what I call the ladder of generality and say, well, we maybe didn't talk about chest pain, but we did, it was all encompassed in that you should have called the doctor. And
No,
our
Your
opinion was you should have called the doctor, and maybe it was for A, B, C, and D, and we articulated A, B, but that we had C as well. And that wasn't a separate opinion. That was just a more comprehensive argument of the opinion we made. What say you?
I would say no, they could not do that, Your Honor. And counsel for the hospital in the discovery deposition asked multiple questions to ensure that they exhausted the nurse's opinions regarding what the reasons for calling would be. And for that, I would cite the court to pages 3503 of the record appeal to 3506 of the record appeal. Counsel for the hospital followed up 3 separate times to make sure that they understood what the specific opinions were regarding the breaches of the standard of care and the reasons why the nurse on August 9th needed to go up the chain of command. So, as you mentioned, pursuant to the Florida Supreme Court and Binger and its progeny, the trial court properly excluded these very limited opinions. As I mentioned, pages 3503 to 3506 of the record appeal go through the multiple instances where the hospital specifically asked the nurse what the specific deviations were. And what I'd like to point to is the language on page 3505, and this is the second time where it was asked. Counsel said, so I need to know the specific deviations. You told me she should have called Dr. Feld to make sure that he was aware of the creatinine result. I understand that. Rather than something amorphous, what is the specific thing you believe she deviated from? And so there it was asked again and asked for specificity. As the trial court properly pointed out, the plaintiffs cannot bootstrap these general allegations with findings in the medical records when the plaintiffs did not disclose these deviations. And there is case law that the plaintiffs cannot idly sit by and know that these opinions exist and that their experts not offering them in the depositions. And that, assuming she actually had those opinions at that time, that's what occurred here.
Okay, so we're past point 1. If we get past point 1, right, and we say that it's not disclosed, then we move on to what our analysis is, the trial judge did. Your opponent says that you're clearly not prejudiced.
Yeah.
What say you?
I would disagree with that. As Binger states, surprise in fact is prejudice. So we were surprised by those opinions. We asked the reasons why, what the specific deviations were, and therefore we were surprised, and that is prejudicial. And the trial court went through the Binger analysis at the outset and is clearly aware of what those factors.
Well, she didn't go through the Binger analysis as to this specific Binger objection. She did it to the one before. Does she have to make findings on the record under Binger?
No, Your Honor. She clearly at the outset of this discussion, which this was very extensive arguments regarding all of these objections. And so at the outset, the very first Binger objection that we made regarding chest pain that she in fact overruled, she went through a very extensive discussion. And to that, I would refer the court to trial transcript pages 258 to 259. And so that shows that she was aware of the analysis that needed to be done in doing the Binger one. There is no requirement that all subsequent rulings that she would have to repeat herself, that the court would have to repeat itself over and over again. There's no case law that requires that.
So you think the standard is as long as we believe that she knew what the analysis was, she could make shotgun decisions without having to specifically state reasons on each of these?
Well, she did state reasons on all of these. She did not go through the extensive.
She doesn't have to go point by point on each of them.
Correct, Your Honor, because this is an abuse of discretion standard, and the Binger case law does not say that for every single objection, they need to have a written or a verbal discussion delineating all of them. She went through a discussion of an extensive discussion regarding each of these objections, and clearly at the outset, she stated that she knew what the Binger objections were and she was applying them. This was not just a mere discussion where she said that an objection is overruled or sustained. She did go through analysis on these other issues.
Counsel, what's your position on the issue of whether trial counsel has a responsibility to point this out to a trial court in real time so that if the Binger factors are not fully analyzed or prejudice isn't properly analyzed on the record, what responsibility does trial counsel have in that situation? If a trial counsel sits back and says nothing and lets the court's ruling go forward without pointing out to the court that they have not followed Binger, is that a waiver?
I would believe it is a waiver, Your Honor, because we would not be at that time able to fix it, or we can't fix it now looking back. There was no issues or questions by the other counsel saying, well, I don't see where you found prejudice here. There was no pushback to say, I don't agree with your ruling, or can you explain your ruling further? So I believe that we have to rely on the outset of the argument where the judge clearly understands the analysis and is doing it each step of the way. The last section was in regards to the respiratory therapy argument. And in the deposition, we asked the expert about the respiratory therapy, and she actually said she didn't understand the notation of respiratory therapy in the record. So she clearly did not hold any opinions that the failure to communicate respiratory therapy was a deviation in the standard of care. I would also like to refer the court to the Baptist v. Rawson case, where in that case, that was a medical malpractice case where the plaintiff there was a defense verdict and the plaintiff moved for a new trial based on new expert opinions, and the trial court granted the motion. The first DCA affirmed the trial court's ruling on the motion for new trial, and specifically found that the surprise testimony that was let in was prejudicial by the defense expert. And there the court specifically states litigation should no longer proceed as a game of blind man bluff. And similar to this case, in the Rowan case, you had a situation where the attorney specifically asked the expert in deposition multiple different times, are these all of your opinions? Are these your opinions? You know, can you specify what your specific opinions are? And that's what was done in this case. Counsel for the hospital asked all of the proper questions during their discovery deposition. And so if these opinions were intended to ultimately be elicited, then the plaintiffs had the burden of disclosing those if their expert did not get those out. I would refer the court to the Conakaris v. Conakaris, Florida Supreme Court for 1980 regarding the abuse of discretion standard. And specifically with that, it is clear that the trial court was utilizing the analysis and had an understanding of Binger when ultimately making these rulings, and therefore a reasonable person could agree with her rulings. Now, the third portion of the testimony that was excluded was in regards to the testimony of the diagnosis of preeclampsia. Nurses do not have the qualifications to admit a patient to a hospital or to order when a patient is to be delivered. They cannot perform C-sections. And so accordingly, the trial court allowed the nursing expert to talk about preeclampsia and what it meant. But the limitation was extremely small. It was just one question. And that was where Nurse Attard was testifying that the diagnosis of preeclampsia meant that the patient needed to be admitted to the hospital and that they needed to deliver. And that is not within the nursing purview. And so for that, I would refer to pages 245 to 246 of the trial transcript. The second issue that plaintiffs are claiming here is that the exclusion of limited testimony violated the plaintiff's due process rights. Even applying a de novo review, that argument should be rejected. The cases referenced by the plaintiffs all deal with situations where the expert was stricken as a witness. Here, she was not stricken as a witness. She offered extensive testimony regarding the purported deviations. And specifically, I'd like to refer the court to the following citations from the record of appeal where Nurse Attard was testifying that the nurses deviated in the standard of care on multiple days. That would be record on appeal pages 5715, 5717, 5718, 5719, 5722, 5723, 5727, 5728, 5733, 5744. These citations all demonstrate that the plaintiffs had the ability, that the plaintiff's ability to have their nursing expert overwhelmingly testify as to the deviations of the standard of care by the nurses, including Nurse Vasquez on August 9th. Based on the above, we believe that the final judgment should be affirmed in all respects. And unless the court has further questions, we will rely upon the contents of our brief. Thank you.
Okay, thank you, Counselor. You recommend?
Okay, we got that set for me. Okay. I do just want to follow up with, I think Judge Smith's question. I'm just going to refer you to 3681 to 3683. I believe in the new trial, the trial counsel did give the trial judge an opportunity to correct the error prior to the appeal. If the 3683 says the Binger standard was not met as to this testimony. So I did want to follow up with that. And let me just say, and there's a lot to cover here. I want to make clear in the discovery deposition of Nurse Attard, she said at, okay, page 3505, she made clear nurses breached the standard of care by not calling the doctor when one takes into account everything in total. And she talked throughout the deposition of preeclampsia, which, you know, abdominal pain is a symptom of preeclampsia, and then the respiratory therapy, and considering her medical chart, and that's what everybody's going by is the medical chart. And certainly Nurse Keith was able to give all kinds of opinion testimony with respect to the medical chart. Nurse Attard was not. And what I find interesting is in the deposition, what they left in, and that was the problem. I mean, they left in some, Nurse Attard could testify to some, data points basically, but she couldn't make the connection, right? She wasn't allowed to say, well, that was a deviation of the standard of care, not to go up the chain of command. With respect to what was showing on the medical chart and how the patient presented. But at page 43, that's R5727 question, and this was allowed in as a registered nurse, when you see the pregnant patient complaining of pain, is that important to you? Yes. And yet, when she's asked the question, this is what was stricken. Upon learning this information of the complaints of pain in the abdomen, tightness, intermittent by way of description from Ms. Lavity, does the applicable standard of care require Nurse Vasquez to have called Dr. Feld or some other medical doctor? Objection. And then that was rephrased. And then she said, yes, the presence of pain would cause any nurse in pre-admission testing to do some fetal monitoring, to call Dr. Feld to see if he's willing to perform an MST. And that is one of the key items that was excluded. And what you've got when it goes to the jury is, okay, remember, the only expert that plaintiffs had basically left was the nurse regarding nursing standard of care, was Nurse Attard, okay? And she was excluded. So the jury, while plaintiffs can say, this fact, they could not present any expert testimony because the key expert testimony connecting the dots, right, with the deviation of the standard of care, the nursing standard of care was excluded in this case. Okay. And I think certainly under the Binger analysis to say that this was surprise, in fact, no way. Read Nurse Keith's testimony. She got to cover all those points. And oh my goodness, on preeclampsia, just read the depo because I don't have time to read everything, but the court has it before them. And I think I quoted it, sure, in the brief. They want to say, oh, well, it's a diagnosis. So she's a nurse. She can't talk about diagnosis. That's not what was going on. She was asked in her experience, what's usually done when there's been a diagnosis of preeclampsia. And there was a diagnosis. Clearly, there's no dispute about that. And yet she was not allowed to testify to that. But Nurse Keith was allowed to testify to that. Talk about asymmetry and a one-sided case of experts. And that's exactly what happened in this case. Okay. So, and why emphasize Nurse Keith is there was no prejudice. And in the third DCA case that I cited, they make it clear that's going to be reversible error.
Counsel, are you talking about the Kalari versus Winklejohn case?
Yes.
So in the Kalari case, there was a motion for reconsideration filed after the striking of the expert.
Mhm.
Did you file a motion for reconsideration?
Oh, I don't recall. I'd have to double check the record, but in the motion for a new trial, though, I know that the trial attorney had raised.
But from a timely perspective, obviously that's after the trial. I guess my point is that as I read Kalari versus Winklejohn, I don't see anything in there where the court says that there's no responsibility on trial counsel to raise this to the judge in real time to let the judge know that they didn't follow Binger. In fact, if anything, if I'm reading between the lines, it does seem like they probably did raise it. It's just not clear. I'm wondering, do you have any case that's a little clearer than Kalari that says that you don't have a responsibility to raise this to the lower court, that it's essentially fundamental error analysis?
I sound like a negative. I don't think that I don't know of a case that requires you to raise that, especially in a motion for reconsideration, right? They're going through, doing all this argument. I don't see where there's a requirement to raise that after the court's ruling, Your Honor. So I can't cite to you a case that says yay or nay on that, okay? And when you go to the depot, because I think the cases I cited, let's see, that's the Suarez Burgos case, 745 Southern Second, 368, and the Allstate case, 14 Southern Third, 1290. Limiting an expert's testimony to the exact wording of his or her written report, however, would create an absurd result. Such reports often contain complex medical terminology, which requires extensive explanation. When you look at the depot, I'm sorry.
Your time's up.
Okay, can I have 30 seconds to wrap up? Thank you, Your Honor. I would just refer the court, look at pages these are examples, 95. And if you look at the deposition, Nurse Attard does touch on a variety of the factors, but she's never really allowed to finish. And they want to harp on, well, he asked the magic question. Okay, do you have any other opinions? Well, as far as Nurse Attard's concerned, she submitted her report. So it's up to defense counsel to pull that report out, say, well, what do you mean by this? What do you mean by that? And that was never done in this case. So for the reasons I rely on my brief, Your Honor, I think the brief covers this in extensive detail. So we would ask that this be reversed and remanded for a new trial. Thank you.
Thank you. Okay, our next case will be 23-3011. CBRE Inc. versus Didier Group et al. Council can approach. Hey, good morning. If I could please have council representative recognize themselves.
Your Honor, on behalf of the different group. What do you mean is file counsel or revenue?
All right.
Good morning, Elliot Sherper on behalf of CBRE.
Okay. All right. Well, ballot is recognized.
You're on.
Would you like to reserve any time?
Yes, Your Honor, if I could reserve 5 minutes, please.
5 minutes. You're recognized.
May it please the court. First question on this appeal is whether the trial court erred in allowing Didier's claims to go to the jury and in denying CBRE's post-trial motion. On the tortious interference claim, the answer must be yes. Didier had no cognizable relationship with the Bandy Track sellers. None. The only relationship, if you can call it that appears on this record is a phone call that Didier made to the broker, Justin Hirsch. He argues that he had a relationship, however, because he wanted to participate in the deal.
Counsel, I find the facts on this, your argument for tortious interference, very interesting. And unlike a lot of the case law that discusses the expectancy problem that seems to divide the state and the federal courts as well, both of them desired to have a relationship, correct? The jury could find that both parties desired to have a relationship
Plumlee
and Brandy track owners.
well, the Brandy track owners wanted to sell the property.
Correct. And didn't they not testify that they thought at some point they actually were dealing with Didier Group?
They did. And it wasn't all that clear to Hirsch until well into the process that Plumlee was off on his own mark.
So what's interesting here, I think, is that there's certainly case law where you have past customers, right? And ongoing relationships, and we flesh that out and how that's different. And we talk about somebody being identifiable versus somebody being part of a group. In some ways, Didier Group was identifiable.
Certainly was identifiable.
So we're not in the large customer base problem.
No, ma'am, we don't raise that argument at all.
And we have a jury that could find that both parties expected or desired to have a relationship with one another, were attempting to have a relationship with one another. And but for a sleight of hand by Mr. Hirsch, I think a jury could find that they would have consummated a relationship. So is the argument that the expectancy only goes to the rights and not to the relationship?
If I could just
Yeah, you can rephrase.
put a pin in the duplicity by Hirsch, part of that
Sure.
question, Your Honor, and because we don't see that at all. But the Bandy track owners wanted to sell their property. DG had been doing business in the area. They thought that DG would be a good customer to buy their property, no question about it. And Hirsch actually reached out to DG, and because he had other relationships with them for other separate deals. And as he told the Bandy track owners, they didn't get back to me. They had other things going on. They didn't get back to me. And in the meantime, Plumlee, who I put going back to my pen, who was the real double dealer here, called Hirsch up and said, I want to buy the property. Hirsch wasn't clear whether he was operating on his own or operating for DG. Wasn't clear whether he was allowed to operate on his own, whether he was a partner or an employee or any of that. And Plumlee came through with an offer. Now there's the oral offer after that, as to which there's a conflict, but I recognize I'm bound by the testimony that an oral offer was made, although I found it interesting that later on, when they had the awkward conversation, Hirsch and Didier had the awkward conversation, Didier said, well, would it help if I made an offer? He actually said that in that same conversation. So I'm confused as to what he thought he was doing, but it doesn't really matter. Number one, the offer wasn't in writing. That's important under South Carolina. But even if it was, that's all there was an offer to Hirsch to buy the $995,000 property for $1 million, $5,000 increase on Plumlee's offer. That's all there was. An offer under Florida law does not create a relationship, period. End of story. And that's all he did, was make it, at best for him, was make an offer.
Counsel, if we agree with you that there was no relationship, right, and it knocks out the tortious interference claim, but if we disagree with you on the aiding and abetting claim, does it make a difference?
Well, we have an undifferentiated jury award, but we also have silence from the other side of the tuition. So I believe it does make a difference.
Can you build that out for me?
Sure. If you knock out the tortious interference claim and all that's left and you uphold the aiding and abetting claim, then I think we're entitled to some sort of proceeding. This, again, this wasn't raised by the other side, to determine what the jury verdict meant with respect to those two claims. But I think I can save you the trouble, because just as the tortious interference claim falls, so does the aiding and abetting Plumlee's deceptive behavior fall. The reason I say that with such confidence is what we have here is a broker who carried out his duty to his clients. His duty was to get the best price he could, and they wanted to sell right away. So he did that. And he's being sued for aiding and abetting because there was a disappointed buyer out there. Now that happens every day of the week in real estate deals. It's happened to me that an offer's made and someone else gets the deal. That's literally all that happened. Now, did Hirsch suspect at some point in this process, he admitted he did, that something funny was going on? And when Plumlee sent that famous email where he was trying to cover himself and said, Well, tell me what else is going on here with the deal for the Bandy Track property. Hirsch had a very frank conversation with him and said, I don't know what's going on with you guys. And I don't want to get involved with what's going on with you guys. I have a client and my fiduciary duty is to his client. So he's being sued for aiding and abetting someone he sold the property to. Well, of course, he did something to help Plumlee. He sold the property to Plumlee. The question is why?
But why is it insignificant that he did not relay the offer? I understand it's not in writing. I understand we're under South Carolina law.
Leaving that aside, as I said, this is what Hirsch knew. And I'm not here to defend him as a paragon of virtue, but I am here to say that what he knew was if he told Didier that Plumlee was buying the property, and at that point he suspected on his own hook, it would have blown the relationship up. As he said, my deal would have cratered because I wouldn't have had the deal in hand. Now you could say, well, maybe he would have had the deal with Didier. Maybe he would, but all Didier had was, according to him, was an oral offer. And he could have said, no, I'm not interested. Meanwhile, the Bandy Track people say, I'm through with you, and they walk. Or otherwise, there's a bidding war that goes on and nobody's satisfied and everybody walks away. He said, I would have blown up the deal if I told Didier, with whom I had no relationship and to whom I had no responsibility, that there was this other deal going on with his partner. And his responsibility was to the Hirsches and to the owners. And the owners very happily sold their property for the listing price. And we're talking about a $5,000 difference. Maybe the Bandy Track owners could have gone after Hirsch for the $5,000, but they went away happy. He had no responsibility to help Didier make millions of dollars from this tax scheme by turning the property into a conservation easement. He had no responsibility, he had no duty, and he had no relationship. His only relationship was with his clients. And that's why the aiding and abetting has to fall just as much as does the tortious interference. We also raised.
Counsel, if I may just jump in.
Yes, sir.
Did you at the trial level ask for the damages to be distinguished between aiding, abetting, and the tortious interference? And if so, when did you ask for that?
Not that I recall, but as I said, the issue's waived because it's not raised by the other side. And it doesn't really matter that much because they both have to fall.
How is it waived, counsel?
It's not in their brief.
But from a tipsy coachman perspective, if we're looking at this and we're finding that the aiding abetting is proper, my read on cases, several of them, are that if we've got one version, if we've got one tort that we can uphold that has the same damages as another tort, it seems to me the cases are pretty replete that as an appellate court, we don't even, if we have a questionable claim, such as the tortious interference, which I don't not concede that is the closer call. I'm not so sure that I agree with you that the aiding and abetting is a closer call. That at least my read of the cases in Florida is that it's pretty clear that we can pick if we've got the equivalent damages on both. And that's why I ask you, counsel, and I appreciate you conceding you didn't raise it. But how can we not, from a tipsy coachman, be able to consider that as a grounds for affirmance?
No, what I'm saying is they didn't raise it. It's their issue.
But why did they have to wait? I mean, they're the appellee. They don't have a burden. You have the burden as appellant.
No, as appellee, they have a burden. I'm not talking about the trial court. I'm talking about here.
Correct.
The argument isn't raised here. And if an argument isn't raised in a brief, it's generally considered to be waived. But I'm flying a little bit by the seat of my pants here, Judge Smith, if I might. I don't see this as a tipsy coachman issue on a trial court ruling. The 2-issue rule is an appellate doctrine with which the trial court never has to concern itself. So I'm having trouble squeezing that into tipsy coachman. But if I can just say this, as I said, I am flying by my seat of the pants on the issue. If the court is interested in the 2-issue rule, I'd request supplemental briefing by both parties, very short time period, perhaps simultaneous briefs. On the issue before I deal with a very large verdict on something that came up in oral argument. Because I don't concede for a minute that if the appellee doesn't raise the issue, that the court can decided on appeal in their favor. But I also don't recollect, quite frankly, because it never came up, what the discussion was about the verdict. And I would like an opportunity to brief that before the court decided the issue.
You can continue.
Thank you. On the damages issue, we have two points. First, and this goes to the entire award. There's no basis for the millions of dollars in damages to Didier. The plaintiff's expert based his calculation of the damages on prior Didier transactions, in which the profits in those transactions were allocated to partially to a separate Didier entity known as Didier Development, which has never been a party to this case. He didn't have any what he called yardstick transaction, in which the only allegedly injured party was Didier Group, which is the plaintiff here. And he used both of their quote profit percentages to compute the damages without calculating, as he put it, what the split between the two entities would have been in the Bandy Track transaction. That's the transcript of pages 671 through 72. There was no damages model presented to this jury for an award of damages to Didier Group alone, and therefore no underlying factual basis for the expert opinion. And of course, an expert cannot provide the factual basis for the expert's own opinion. So without a damages model, there's no entitlement to recover those damages. They're deemed to be, and properly deemed to be, speculative. The second damages issue is a set-off for Didier's settlement with a co-defendant RCP, which was an entity created by Plumlee as part of the transaction. Didier does not dispute the applicability of the settlement set-off statutes, which is sections 46.050152 and 768.0412, or that identical damages were sued for against CBRE and RCP in the complaint. And of course, they can't, because the complaint says what it says. And the settlement does not allocate payment among the claims against RCP. The aggregate, therefore, the entire settlement, whatever it is, it's confidential right now, and the trial court did not order it to be released, should be set off against the jury award under the rule most recently stated by the 4th District in the Cornerstone case, where a settlement is undifferentiated and general. The aggregate of the amount settlement should be set off against the judgment.
Counsel, I'm having some trouble, and I'll have questions for your opponent when it comes to the set off. But what I'm having some trouble with is identifying their argument, which seems to be that they already got a haircut when it comes to the attorney's fees against your client. So why should they take it twice? Is that what you see their argument to be?
I don't understand their argument, to be frank. But the attorney's fees are over here. They're not part of the damages award. And if they want to make an argument that they're entitled to something for their haircut, then we need to know what the settlement was. Because if the settlement made them whole, despite the haircut on the damages, then the settlement walks us away with no damage responsibility.
So we
If
have,
the settlement was for a nickel, then it's something else.
so we have this rule. It comes mostly, it looks like, from the 4th DCA, that if you have an undifferentiated settlement, then we're going to apply it against the award in general. There are some situations where that makes, I guess, when you have evidence, it cannot be challenged. If you have evidence that the claim, that you have identical claims, but that the amount went toward the claims that were not identical. Let's say you have overwhelming evidence. Is there any support in Florida law that there's a process for ferreting that out?
No, Your Honor, there isn't. The answer is do it at the beginning.
Mhm.
That's what the 4th District said in Addison. Is don't come in afterwards and say, oh, it was allocated. Do it at the beginning. Allocate it at the beginning and you're fine. If you don't do that, you run the risk of exactly this situation. That's the way you protect yourself, is by allocating among the counts. And we know that that didn't happen. That's all we know, or that's all I know. But the amount is the amount. I don't see any support in the case law for
Any alternative framework?
making them whole on attorney's fees in the context of a post-trial settlement. They're entitled to the damages once, period. And if they get the damages twice, there should be a settlement. And there's no law to the contrary.
You're into your rebuttal time.
I'm well into my rebuttal time, Your Honor. I'll rely on my brief for the remaining issues and salvage my few minutes.
Ms. Humphries?
Good morning. My name is Celine Humphries and I represent the appellee. I want to make an initial comment regarding the two issues that my opponent focused on the most, and that's the arguments for directed verdict and their argument regarding damages. All of those arguments are not before the court for review. Regarding the directed verdict arguments, the defendants presented an argument to the court that did not comply with the law that governs a request for a directed verdict. Their telling of the case was based almost exclusively on the story of their client's employee, Justin Hirsch. The law for a directed verdict requires instead for the movant who wants a directed verdict to acknowledge all of the evidence opposing their request, and if any of it's debatable, to construe evidence in favor of, in this case, affirming the jury's verdict. Excuse me. In response to every question you asked, and particularly you, Judge Nordella, when you received an answer, it was relying on Justin Hirsch's telling of the story. So since they brought this argument to you improperly, we don't even get to the merits. Similarly, when you get to the damages issue, they have not preserved an issue for you to review. And I was painstaking in my brief going through each point. First and foremost, as the court has identified, they're asking to undo the damage award, but this verdict form did not differentiate amongst the different damages. And I apologize, very long telling of the facts, so you did have all the facts. One of the things I explained is that the profits that are earned in this sort of deal are a number of fees. They're only attacking one aspect of that, and that's the developer fees. So it's critical that this verdict form does not differentiate amongst the different categories of fees. And importantly, they didn't even ask, and I say they, different firm, different trial counsel, did not ask or request for a damages verdict form to differentiate among the fees. So we don't even get to damages at all. But there's other points too I want to make why the damages argument is not preserved. First, to the extent there was any suggestion possibly this could be a remediator, we responded in the answer brief explaining all the reasons why this was not a remediator. They have not disagreed in their reply brief, and I won't summarize that again now unless you want me to. What they did disagree is when I said, you've not requested directed verdict on damages. And they said, sure we did. Look at the conclusion. The conclusion says it. And I couldn't reply to the reply, but the answer to that is a conclusion is not where you put your legal argument. If you're requesting directed verdict on something, you actually put it in the argument, or at least in the heading, which here the heading said simply reversed. And it's even more apparent when you compare the argument on damages to the argument on the two counts. Two counts fulsomely discussed directed verdict, never mentioned in damages. So then we go to the new trial issue. That is not available for review either. And the reason is their argument for reversing on damages is they say this is a question of law and it's de novo. And that's the argument that's repeated here. It's a question of law for you to review in the first instance. The cases they cite disprove that. So when they responded to our argument in the answer brief, they cited the ICMFG case for the principle that when the question on damages deals with a legal questions reviewed de novo. If you look at that case, Judge Wallace's case at the second DCA, it's actually dealing with the fact that there a trial court had held that a determination on liability had reached in to also determine as a matter of law two of the elements for damages being nexus and causation. That's not here. But if you look at that opening paragraph where Judge Wallace or the Second District Court of Appeal states this principle that legal questions are reviewed de novo, if you look at those two cases, they deal with the methodology issue. Katz is the first one, and Katz says the question was, should the damages be determined based on lost profits or market value? The other case is, I just forgot the name of it, it begins with a D. It deals with whether or not the proper valuation of damages should be looking on something called reliance damages or lost profits. There was no debate here. The debate here on methodology was agreed. that the plaintiff's expert used the methodology of extrapolating lost profits from previous Group deals and from this actual deal when Mr. Plumley implemented it. CBRE's expert agreed that was the proper basis. So you have that legal issue, it's not disputed. The only other legal argument that's made, and this is what CBRE focuses on, is that one business can't come to court and recover damages sustained by another business. We didn't respond to that because we agree. We don't disagree in the trial court, we don't disagree on appeal. The point here is the application of the law to that standard. Is this a circumstance where this party, Group, was seeking to recover profits earned by a sister corporation? That's a factual question. That's a sufficiency of the evidence question. That was raised in the new trial motion. The trial court rejected it. So there's two problems here, right? The first is the reason why we don't even get to this issue. They ignore that inquiry, the inquiry they had to make. Even in response to our answer brief, they do not do the proper careful thing, which is to offer an alternative argument. In the alternative, even if we have to meet that standard, we could. So we don't even get to an analysis of the directed.
Counsel, can I get your position on if your tortious interference claim falls, what then? If your
So-
aiding and abetting claim stands, but your tortious interference claim falls.
So I heard two questions there, and I'm going to go to the one I think you're more curious about. But if that happens, it is black letter law that all the damages are affirmed if it is based on one count. There is no obligation for me as the appellee to tell the court what the court already knows and does, and following and reviewing a verdict. So you have two different counts that are being challenged on directed verdict. All we have to do is prevail on one, and then the damages flow through. Let me say that another way that just occurred to me because I'm still surprised by this argument. If a party asks to reverse a count, saying some element wasn't proven, and the court reverses it, meaning it reverses the damages that flow from it. If a court is asked to reverse the count and the court decides not to, it affirms the count and the damages that flow for it. It's just the way it functions. There's no burden, obligation, or something I missed by not saying that to the court.
And counsel, I'm sorry, keep going.
Oh, no, you're more important here.
Set off. Can you address set off for us?
So set off, I think, is the hardest argument. I'll tell you where I'm coming from on set off, but I heard your well-taken questions.
Right. I see you're arguing abandonment. I don't quite understand that. If you could
Yes,
flesh
yes.
that out, that would be.
So
appreciated.
I think this one's murky to tell the court the truth. But I think what will happen is if you do reverse on it, we will be remanded, as counsel said, for proceedings. And what would they be? Evidentiary proceedings. So that's part of the point here, where you have a settlement. And there's no question, there's no debate that this settlement, and I understand that you know, based on your questions, there's no debate that this settlement included not only to compensate Group for the damages flowing from the harm, but to also pay Group for the fees that were owed by that party. What happens in that instance?
Wait, can I stop you right there?
Yes.
Is that also undifferentiated in the settlement agreement?
It is undifferentiated, or at least we did not dispute that. I wasn't trial counsel, but I can tell you in where it matters in the record, we didn't.
So we don't know going back, the trial judge is not going to
That's a
know.
better way. I don't know. But what I can do, and in all fairness to counsel, I did not say this in my answer brief, but what I can do based on the questions I'm hearing is if the court is aware of the proceedings dealing with ACA, where it seeks to recover Medicaid funds that it is paid for plaintiff's personal injuries, and that plaintiff settles, then there are proceedings that have even from Florida gone up to the United States Supreme Court where ACA is allowed to recover some of the recovery in order to be compensated. And I might be saying that a little too briefly, but the idea is if the state uses federal funds to pay the medical bills for somebody who's been injured using Medicaid, and then that person recovers and gets paid, the state's like,
So counsel, your position is there should be an evidentiary process where the trial judge determines what's identical and what is not.
like
Does-
ACA.
And if we were to say that, if we were to say it's like ACA, would we be in conflict with the fourth DCA?
I think you would be.
And why is the fourth DCA wrong?
I think that fourth DCA is actually, frankly, allowing a defendant to profit. So one of the things I cited in the brief, and this is the point where I probably was too quick, and frankly, it was a long brief, is there's so many cases that talk about plaintiffs cannot use different mechanisms so that they actually earn money. And you see that a lot in the collateral source context, for example. Getting injured by somebody is not, and I know this isn't an injury case, but whatever the plaintiff, you cannot use a lawsuit to actually come out ahead. You're only seeking to.
Right, there are collusion concerns.
Yes, collusion, yes. And you're just seeking to be compensated. Well, the opposite is true. It is not fair for the defendants to escape part of their obligation. So here, there would be no doubt that the jury would have decided the damages were X amount. And that is the amount that Digigroup is entitled to receive. If the defendant prevails here, Digigroup will not be fully compensated. It will not be fully compensated for the award that the jury determined amounts to the damages sustained. Because part of the compensation that they want credit for was compensation for attorney's fees, which was available to them under completely different reasoning and having nothing to do with the cause of action. I feel like I kind of mumbling here. Am I making my point?
No, I appreciate it. I guess, is there any sister court that endorses an alternative framework for differentiating damages?
I think this has not been addressed.
So we would be the first court to create a new framework post-trial for differentiating damages.
I say that, yes. And
then we get to why would we do that? What is the right decision to make?
Well, and that's why you look to other, so you're not the first court to acknowledge that there's an issue that the court can't determine. Said another way, it's black letter law again, that questions of fact and evidentiary issues are for the trial court. Appellate courts don't hold evidentiary hearings. There are many contexts where the court goes, we don't know.
That's true. Counsel, what's your rule? If we endorse this new framework that no court has ever found, what is the rule that we would give the trial court?
The rule is that if there's a possibility that let me start this way. We do not dispute the set-off statute applies. And we understand what the set-off is about. Where a party is seeking to set off for more than the damages that are recoverable by some other amount. In other words, the set-off that they're seeking is for more than what Rice and Corner paid toward the damages.
I'm confused, counsel.
Okay, I'll say that again, because I can see why. The set-off statute says a jury determines that the damages you sustained are $100. We understand that another defendant already chipped in 20 towards it, so defendant left in the courtroom, you only have to pay 80. That's what the set-off statute says. We recognize it, and frankly, it's justice and it makes sense. But where the $20 that was received, only 10 of it was to pay for the harm sustained, and the other 10 was to pay for, maybe I should adjust that, 8 was for the harm sustained and $2 was for the attorney's fees. The set-off statute does not require, and the policy behind it does not, the express language in terms of the set-off statute, so which is obviously very important, and the policy does not mean that the defendant who's in the courtroom gets that benefit of another defendant having chipped in money to pay its obligation for attorney's.
So would the argument be that following the fourth DCA's model does not honor the text of the statute?
It doesn't honor the text of the statute, but more importantly, and the argument I've been leaning towards is it's unjust. It means that the defendant in the courtroom is escaping its share of the responsibility for the damages occurred, simply because that settlement also included a separate claim to which that defendant is entitled to no benefit. And that separate claim, and I keep saying attorney's fees, but it's attorney's fees and costs, that they're getting the benefit of that. And that's not what the set-off statute is about. And that's letting, CBRE escape a part of its damages that this jury determined it is liable for. That's the concern.
Counsel, you're also making an argument about attorney's fees. And could you build that out for me on how attorney's fees in here were allocated separately? Obviously, the trial judge went through what was related and what was not. And you seem to be making that they would be getting a double recovery. Is that a separate argument than the one you just made?
It is a separate argument, but what I'm really doing there is acknowledging or pointing out that they themselves acknowledge that we should separate attorney's fees when it helped them lower their responsibility for the attorney's fees. So when we came to the hearing seeking attorney's fees that incurred to pursue the trial, I do want to make sure I made this point clear. We already had cut out the attorney's fees that we thought were related only to this other party, but there were some that were debatable. They won almost that entire argument. They won a lot of that. And so they said, whatever, all the money and fees and costs you incurred for this trial, you can't make us pay those fees that are somehow particularly relevant only to a defendant who had already settled on debatable issues. So in that context, they were able to minimize their responsibility for the fees and costs that they owed after losing the trial. Over here, in the context of the damages, they want to close their eyes. That's the point that I was trying to make. Now I'm gonna make another point. So I do want to hit on something. Well, when you asked your question about what is the consequence of if the court rejects the tortious interference claim, that one of the answers given to you was that means the aiding and abetting has to fall as well. And I can go through all the evidence if you want, but I want to say something really obvious in response instead, or at least first, and that is there are two different causes of action with two different set of elements. And they have different facts that relate to each. And I don't think I could have been more painstaking in lining up the evidence that at least all I had to do was establish that a jury question existed. They do not go hand in hand. But to the extent one of the arguments you heard on the tortious interference was, goodness gracious, all Mr. Hirsch was doing was was honoring his duty to his clients. That ignores evidence. The most important thing, that he lied to his clients. So Mr. Hirsch testified to the jury, I told the sellers it was not Digigroup, it was Blake Plumlee purchasing this. And they knowingly decided to purchase from Blake Plumlee. Now, the sellers, as I kind of cutely said, had no dog in this fight, and they unequivocally, and one of them even angrily disagreed. They didn't find out about this, they testified, until they became witnesses in this trial.
Counsel, is the expectancy interest, is it an expectancy interest or is it an expectancy in the relationship? I see language in cases that's you could make an argument both ways. Is it enough that there's just, well, let me ask this. Did they have a relationship or did they just expect to have a relationship? Is it enough that they expected both to have a relationship with each other?
So I thought your question was fascinating when you asked my opponent, and now I understand better. I don't think I can fulsomely answer you on that, honestly, but I don't think I have to. Because here, what the evidence establishes or presents a jury question that they both expected that they were consummating the actual deal. The heck with the relationship. It was the deal. It was the relation, you have relationship and then you have deal. And in fact, tying to, and perhaps why you asked this, my comment just a moment ago, the sellers thought they had. The sellers thought they had, and it's what they wanted. And to the point of them walking away happy, no, that's the very angry testimony by one of the sellers, Darla.
Right, we read the depot.
Okay. So, so I think regardless of whether, and that is a wonderful nuance, and I wish I could engage in that analysis with you better, but I do strongly believe in this case, the facts establish that what would have come from it is in fact the existence of the deal would have happened.
But we don't have a case to base that model on, correct? This would be a new factual scenario where there's a
Disagree until your last sentence.
Okay.
So the cases say, first of all, I do want to stop for a moment if I can. One of the reasons that their argument fails is that they did not present the argument based on a prospective relationship. Their argument was to misstate the law and said it had to be an existing relationship and not the prospective relationship. So the prospective relationship is that, and I just, to make that point, I think I lost the thread to answering the question you just asked. If you could answer it again, or answer it again.
I wish I could.
Uh,
I think you get my general curiosity though.
Yeah.
If the expectancy can go toward the relationship or it just has to go toward the rights. And if there was any case law which. had
Oh, that's
gone-
what you asked. Is there any case? And now I interrupted you, but I think I understand. No, this is a concept that is case by fact. So the situation that we don't have this exact circumstance where a seller's like, oh my gosh, I have a buyer. I'm going to go sell to that buyer, even calling him a targeted buyer. And the buyer's like, oh my gosh, this is exactly what I wanted. And then you have the two perpetrators here like, oh my gosh, we have to keep them apart. Do I have this whole situation in a case? No. That doesn't mean this is a case of first impression or this is the court's going out on a limb applying other case law. It's simply the law of
Your position is we wouldn't be expanding the law
No.
to recognize something that has yet to be recognized.
I wish I'd said it that way. Right. It is simply applying existing law to the facts here. And then what I would suggest if the facts here are so remarkably strong for that law to be applied to. I think one reason why you might not find case law saying it is this circumstance is pretty, unfortunately, pretty unusual.
A little under a minute remaining.
I'm sorry.
A little under a minute remaining.
So some of the arguments were not addressed by my opponent at oral argument, and I tried to provide it, and admittedly, you allowed me to exceed the page limit. Would you like me to address any of those issues now? Do you have any other questions on arguments not raised by my opponents? On the other issues on appeal? I just want to say I very much appreciate the time to appear before you today. Thank you.
You recognize Mr. Sugar?
Thank you, Your Honor.
Council, I'm very interested in your thoughts about the idea that there should be a separate framework for determining set off that conflicts with the fourth DCA.
Well, the statutes say what the statutes say. And as people are fond of saying, we're all textualists now, and the statutes don't admit of any exceptions. I see the issue of attorney's fees in a case such as this as over here. A determination was made by the trial court on which fees were awardable and which fees were not. I went along with calling that a haircut because in some sense it is, but it's a haircut that the trial court based on its determination of facts and its application of the law. So they were not denied anything that they were entitled to under that view of the proceedings. They were denied that to which they were not entitled because the case didn't go to trial against RCP. And what they're trying to do is say, okay, we lost over here on fees. We're not entitled to those fees and costs, but we're going to get it back over here.
Well, isn't their argument maybe better stated that they're saying there's no longer an identity of damages because we know that there is no overlap as the attorney fee claim, there's no longer identity for you to subtract from. And I guess your argument would be, we don't know because they didn't differentiate. We don't know what belonged to attorney's fees and what didn't.
Exactly. But the case law is very clear in cautioning. And if you read the case law before you enter into a settlement agreement, you know what to do. And if the other side that you're settling with doesn't want to do that for whatever reason, and you agree because you want the case to go away, then you wait.
How would their framework not be a textualist analysis?
Because there's no exception for a separate attorney's fees award in the
Well,
statute.
I think what their framework would be, you just go to the trial judge and the trial judge is going to ferret out what is what on the settlement agreement and then make sure it is applied based upon his evidentiary findings.
I think the
Is it
case
not
law,
just, sorry, is it not just a different framework for satisfying the same statute?
I would disagree. The case law of which the legislature was presumably aware when it reenacted the statute every year doesn't give trial judges the authority to ferret anything out except was this an aggregate settlement or not?
So it's a soil cannon. It brings the, sorry, go ahead.
I don't think I've ever heard that phrase. The trial judge makes a determination. They don't have to make that determination. The judge doesn't have to because they conceded it. It's an aggregate settlement. So that's off the table. The only question is how much? And we're not recovering a nickel more in damages under the settlement than we got from the jury. We got then they got from the jury that we have to pay. We're not getting out from underneath anything that we're not entitled to get out from underneath. We're just saying we pay it once. We don't pay it twice. And we need to know how much the settlement is to find out if we're paying it once or paying it twice. There's one other point I'd like to make very quickly. I wrote this down because I don't think I've ever heard this before in an oral argument. I don't have to tell the court what it already knows. And talking about the 2-issue rule. I've never heard that before, and I think for good reason. I think we're obligated to tell the court what the court knows in making our arguments in an individual brief. And if we don't, we've waived it. And that's what we submit the situation is here on the 2-issue rule. We'll rely on our brief for the remainder.
Counsel, I mean, would you concede in your appeal that there was a possibility that you might win on the tortious interference and you might lose on aiding and abetting or vice versa? Did you know that before you filed your appeal, that one issue you might win on and one issue you might not win on?
Theoretically, Your Honor, of course.
So shouldn't you have then anticipated that the 2-issue rule is going to come up in this court, which, like I said, is replete throughout Florida law and oftentimes mentioned by appellate courts as almost an afterthought at the end of opinions of we've got identical damages on these claims and therefore we don't have to get to claims 2, 3, or 4?
Your Honor, the honest answer to that question is I truly believe that there isn't a factual world in this case where I could win tortious interference and lose aiding and abetting. They arise, if I might, Your Honor, finish answering the question. They arise from the same factual nucleus. There isn't a set of facts here on tortious interference and a set of facts here on aiding and abetting. They're all the same acts. And if you read the 89 pages of brief that my opponent filed, you'll see that there's not a separation. The tortious interference started here and ended here. And the aiding and abetting started here and ended here. They completely overlap. And our overarching point is that whatever happened between Didier and Hirsch, between the Didier group and Hirsch, nothing happened that made CBRE liable because Didier didn't achieve his expectation of making millions of dollars from buying a $9,995,000 piece of property.
Thank you, counsel.
Thank you, counsel.
Thank you, Your Honor.
Excellent argument. Appreciate that. All right, we're gonna be in recess for about 10 minutes.